Good evening, everyone, and welcome to the fifth installment of Operation Safe Spaces Family Law Seminar. It is my distinct pleasure this evening to welcome our presenter, Dr. Marsha Hinds, who is also one of the OSS project managers, who will be taking us through the Domestic Violence Protection Orders Act. Again, a couple of quick housekeeping notes, everybody. Well, there are a few newcomers. So please allow me to introduce myself. My name is Robin Paris, and I too am one of the members of Operation Safe Space. A couple of quick housekeeping notes before we get started. This will be more of a presentation format, and Marsha may pose questions during the presentation, but for sure there will be a question and answer segment towards the end of the presentation. At any point, if you would like to ask a question, please feel free to use the reaction button and raise your hand or unmute your mic. These sessions are being recorded, and so if you haven't already done so, please complete and return the consent form. And don't forget to check us out on social media, both on IG and Facebook at OSS.246. And without further delay, let's get started. Thank you, Marsha.
Good afternoon. Thank you, Robin. Good afternoon to everyone who has joined me. I propose to get right into the meat of the matter. We've been doing, this is, I think, installment number 5 of these sessions now, and I know many of you are anxious to get into the law of the thing, and that's what we propose to do today. And you might be asking why a non-lawyer is taking you through the law that is Cap 130A. And there are a few reasons for that. We want out of this experience for attorneys at law in Barbados to get a better understanding and hopefully a lot more comfortable with the integrated approach to solving problems that the Cap 130A addresses. You would have noticed that at the beginning, Rashad did the gender work. He is usually the one who is more doing, the legal training, so on and so forth. And I, who am an advocate and very non-lawyer, is taking you through Cap 130A. Again, like I said, very intentional. This is an experience in what we call gender mainstreaming. We come up with all of these terms and we use them. We use them at United Nations meetings, at IDB meetings, but then I find that there's always a lag in terms of the uptake of the concepts. So gender mainstreaming really means that gender is lived and it is a part of all of our policy and a part of all we do. And if you really think about gender mainstreaming in the law, then one of the things that we have to become more comfortable with is that the law will belong to stakeholders beyond the actors in court. So stakeholders beyond the attorneys at law, beyond the magistrates, so on and so forth. It really will belong to ordinary people in the street. I think I don't think it is a secret that a lot of the things that we consider in Cap 130A have been strongly embedded in law coming out of movements like feminism and womanism, everything that happened with postmodernism and the challenge or the refutation to grand narratives, and our insistence on naming and calling out things like patriarchy and misogyny. And traditionally, when we thought about the law, we thought about the law as, like I said before, grand narratives. It was unaffected by these things that occur in our society generally. But now our understanding is the law does not actually live outside of the society, and the law is created with a lot of the thought and a lot of the, I guess you could call them, stereotypes and norms of the society embedded. So with that little overview of how we are doing it, I want to get right into the first slide. I will do a couple of slides just to kind of, I always make sure that I give objectives of the session, a broad orientation, and then we jump right into Cap 130A. So this is what we should have done by the end of the session if I am effective, and we are going to get right into it. With this first slide, give me the next slide, please, Robin, thanks. Right. I want to kind of contextualize where we are in Barbados in terms of the law. This is how I experience the law as an advocate. I do not experience the law as an attorney at law. Like I said, I experience it as an advocate who is bringing women affected, women and girls affected by intimate partner violence, domestic violence, or sexual violence into the legal space. And I hope, based on the work that Rashad has done, you understand that there is a clear and distinct difference between domestic violence, intimate partner violence, which is a form of domestic violence, and sexual violence, three completely different things. One of the things that we have to understand then is how individuals experience the law. The law in Barbados is a very punitive construct. People are supposed to only come to the law when they're in trouble. They're supposed to come to the law. There's supposed to be punishment. There's supposed to be judgment of who is right and wrong, so on and so forth. There are entrenched patriarchal views embedded in law in Barbados still to today. So access and maintenance are interpreted from the perspective of the father in Barbados. And no matter how over and over I try to impart, access and maintenance are children's rights. They're the right of the child. And the convention that actually sets them down has a specific condition, one specific condition that is supposed to overarch any other, which is that a child is not supposed to have access if that access puts the child in any kind of danger. And danger is broadly defined. It's not only physical danger. But because of our patriarchal gender norms, this understanding of a child's ability to have the right to access or the right to maintenance is something that we don't seem to be able to understand in court. So we interpret them as rights of the father. We have law that is steeped in traditional views about specific people. So women and how women experience life. What is a worthless woman? What is a woman deserving of respect? We have these views that make us treat working class people or people who might not read to the same level that we read to, young Black men who have in some way become in conflict with the law. The way that we experience law because of our colonial history is that we stereotype and treat each of these or these various types of people very differently. And Cap 130A is really demanding that we change all of this. In order to effectively administer 130A, we are going to have to change the way we think about a whole set of things in Barbados. And I think it is why this law, although it has been on our book since this particular amendment since 2016, it hasn't gotten the traction and it hasn't gotten the support that it should get and needs to get to be able to save life and limb in Barbados. Next slide. Thank you. So Cap 130A is an act that delivers remedies to victims. Remember, it is not, like I said, this whole concept of a punitive law. That is not the intention of the law. The law is not to, give woman any right over man. That is not what the law seeks to do. Of course, there are people who interpret it that way, like I said, because of our colonial experiences and how we view law, so on and so forth. But that is not the intention of the law. The law is supposed to be a law that delivers remedies to victims who are affected by intimate partner violence, domestic violence, and sexual violence often cohabits with the two of those types of violences. So the most absolute purpose of this law is to preserve life and limb. That is what it is supposed to be doing. And like I said, that orientation, that understanding of it seems difficult because we want to take it and put it into the traditional mold of how we think about law. The law is a 21st century update to an older version of the law and then older things still that would have gone before. But the point is that this act is informed by a different interpretation, and the concepts of some things such as the public and the private sector divide and gender roles are different. So before in our society, we grew up with granny or auntie or whoever saying, what happens in this house stays in this house. Keep your mouth shut. What happens inside is supposed to be inside business. But that public-private divide is broken because, like I said, we now have different theories that explain that the way that, for example, women experience lives, that divide can be very detrimental. And so we are challenging that divide. And we're also challenging gender roles. So whereas one time it would have been acceptable for a man because he was the breadwinner to come home, and if he decided to go to the supermarket, he went. And if he didn't decide to go, Granny would walk down the road and beg, the neighbors for a piece of yam, and beg somebody else for breadfruit to keep the children fed until he chose to spend his money. We are now challenging the way that those things happen and the way that they are accepted. And like I said, in Barbados in 2021, we are still really grappling with those things. And as we continue to grapple, the world moves quicker pace and ahead of us. So the Act is also in line with obligations and commitments that Barbados has made to various bodies, when we get money, when we get technical support, so on and so forth. So this Act really is not, something that we can just decide, oh, well, we don't agree, this is not what we want to do, and set it one side. And I say that even as we don't agree and set it one side, in my opinion. But we have this Sustainable Development Goal 5, for example, where we are supposed to be reaching gender equality by 2030. We also have the Convention on the Elimination of All Forms of Discrimination Against Women and Girls that we report to on I think it is a bi-yearly basis. So Barbados has commitments, okay? And this law is supposed to bring us closer in line with being able to adhere to those commitments. Next slide, please. All right, now, remember I talked about that breakdown of the public-private divide. This is just a pictorial of the way that we have separated that. So one time, domestic violence or intimate partner violence was seen as an inside issue. The woman deals with it, or the family deals with it if the family gets involved. It was seen as happening at the level of a family or happening at the level of an individual. We have now changed that with the deconstruction of the public and private divide. So the law can now reach into your house and tell you when you're behaving poorly, even inside your house. And that is very different, like I said, and it is not cultural, it is not culturally normal for us as Barbadians. But we do recognize that domestic violence is something which can destabilize an entire community, an entire economy. And so the government and those arms of government that pay attention to people's behavior and the regulation of people's behavior have a vested interest in being able to offer remedies. So CAP 130A must not only offer remedy at the level of the family and the individual, it must also offer remedy at the community and the level of the wider society. Next slide, please. Okay, so in a nutshell, these are the changes, the new additions that we will find in 130A when we go through it with a fine-tooth comb. I just thought it would be useful to categorize them into broad themes. So this slide is basically the way that we have added to the Act and changed the Act to be able to deal with some of the commitments, like I said, we have made, some of the ways that we now understand the pandemic of domestic violence differently, the way that we understand the lives of women differently, the way that we understand the impacts of things like domestic violence and intimate partner violence on children differently, so on and so forth. So these are basically the changes and the expansions in the Act. And I think this should be the last slide. Yes, okay, good. So now we take a close up at the Act. We want to look at the intentions of the Act. We're going to tease out some definitions. We're going to look at pairing the Act with other statutes because, as you know, domestic violence in Barbados is not an offense in and of itself, but there are offenses that can arise. So you may have a charge of assault, you may have a charge of rape, you may have a charge of molestation or incest. So there are ways in which the Act has to be paired with other statutes to be able to treat to a situation holistically. And I think that's an important point because I think, you know, in my 20 years of practice as an advocate on the island, I have always been dissatisfied with the way that a single matter moves through various statutes. So we tend to feel as though once the protection order is in place, there is not need to do more outside of the protection order. The protection order is one remedy by itself, but it does not preclude the victim from having other remedies under the law. And I find that instead of offering that full suite of remedies, we usually tend to try to dissuade people or to get them to go away. Even sometimes getting the protection order itself can be very difficult. So with that little bit of context, I want to look now more specifically at the act. You will see me looking away because I have it on my screen as well, just to make it easy to follow. While Robin is pulling up the act itself, let me just say, I remember when women like Nalita Gajada and Marlene Rice Bowen were sitting at the UN hours and hours and hours poring over this act, dealing with all the dissent that came from it, so on and so forth. There are some gaps in it. We can talk about that in the question and answer, but generally, I think the act offers a lot of opportunity for people who are affected by intimate partner violence to be able to readjust their lives and find solutions and answers. And I'm hoping and praying that we can continue to be able to invest in the act and to allow the act to do the work that it was set out to do. So on this first page, I want to talk about the expansions because there are ways in which our traditions and our cultures, like I said, hinder the very expansion that the act was trying to make. And I sometimes wonder when I see the interpretations of magistrates, when I see the interpretations of attorneys at law, when I see the interpretations of the police, if they are aware that there is an intentional statement of what this act is supposed to do differently or to do better than the previous act used to do. It makes a provision for a comprehensive definition of the term domestic violence. Domestic violence is no longer only characterized as physical violence. It expands the classes of people who are considered to be victims of domestic violence. And I want to say right here off the bat, it includes children who live in households affected by the instability of domestic violence and intimate partner violence. And you can read point B and then tell me sometime in the discussion, how do you juxtapose the extending the classes of persons with the Chief Justice's recent ruling that there has to be a limitation on the word former, okay, when the act seems to be saying the complete opposite in its explanatory notes. In its objectives, in its objects and reasons, and not explanatory notes. The act wants to ensure that victims can receive appropriate counseling and therapy. Are we doing that? It wants to treat to perpetrators. Are we doing that? I don't think we're doing it because there are sometimes where there's a particular, a woman would come and she would start to characterize an experience that she's having. And before she's finished the story, I will tell her the name of the man that she is with. And she is surprised. But the reason why I'm able to tell her is because I've rescued another woman from that perpetrator at a point before. So really, we're not dealing with the issue. We're dealing with the symptoms of the issue. Extend the classes of persons who may intervene. Now, we in Barbados still think that intimate partner violence, domestic violence, these kind of violences, sexual violence are caused by things that victims do wrong. So if a man, luckily I'm not seeing as much of this anymore, but the first question used to be, who she horny with? That kind of thing. It was always something that the victim did. And so if we understand it differently now to be the cycle that it is, to be the absolutely debilitating experience that it is, then we want to add to the classes of persons who can intervene on the behalf of a victim, because we understand that it is not really anything that the victim does. This is not the fault of the victim, and that for the victim to be rescued, there needs to be a multiple engagement to be able to realize that. And we want to establish the duties and the powers of the police. And the reason why we did that, again, is because of that deconstruction of the public-private divide. At one point, you go to the police for a family matter, the police will tell you straight, we can't get in that. That's an inside thing. Y'all gotta try to solve that. So now that we are saying that the community has to have an engagement, and the community has to have a response to intimate partner violence, the police have to have powers, and they have to have powers that reach into people's homes. And as uncomfortable as that is, and as culturally difficult as it is, It is important for the protection of life and limb. And we want to be able to maximize the safety and the protection of victims and ensure that perpetrators of domestic violence are what? That they're held accountable. We still have this belief in Barbados that when a woman seeks to hold her perpetrator accountable, she bitter, she vex, she need to get over it. Accountability is not the same thing as being upset or being vexed or wanting to exact revenge on anybody. Accountability is exactly what it is, accountability. And the profile of an individual who will perpetrate domestic violence or intimate partner violence calls for accountability. Accountability is actually a part of the way that you get a situation to stabilize. So accountability is a very important part of what we are doing as well. So after the objects and reasons now, we have, I'm going to skip the page on the way that the act is set up because the lawyers will know those things better than me. We come right down into the definitions, and there are a few that I want to highlight. I want to highlight the fact that child abuse has been added to the Protection Orders Act. I've been working with this act since 2016. It is now 2021. I am yet to see any case of child abuse that arises out of the fact that a child is in a home that is affected by domestic violence and intimate partner violence. So that simply says to me that the provisions are not being utilized because there are several children in Barbados. We talk about their bullying on the school bus. We talk about their inability to perform in school, but we do not connect that back to the household instability that many of them grew up with. We have a 29-year-old man today who has been charged with a double murder in Barbados. And I will bet you my paycheck for this month that if you look far enough back in his history, there is family instability somewhere. An individual does not come out of a quote unquote happy, healthy, harmonious family environment and end up killing two women in that brutal way and disposing of their bodies as he did, so on and so forth. That behavior speaks to a very particular set of events that he has experienced. So we have this provision to protect children. We're not using it. Cohabitational relationships have been included in this act because we know we like a sometimes as Bajan people. So we like to do them, but we don't like to deal with the reality of what happens arising from these sometimes relationships. So because of the historical reality that is Barbados, the way that our families are structured, we have to then accommodate for the relationships that we like to have. But we like to have them, but then when a woman comes and she finds herself in a particular circumstance, we judge her. And I you know, that part of it outside, like I said, of the colonial relic, I've really never understood. I'm going down and I have all the ones that I want to pause on highlighted because I'm sure you know the act. Like I said, this is not me trying to teach lawyers law. What it is me trying to do is connect some of the theory with the actual law so that hopefully you understand the administration and why the law is written the way that it is written. Hopefully as well you understand, like I said, that it is not meant to punish anybody. It is meant to preserve life and limb. So a domestic relationship means the relationship between a perpetrator of domestic violence and the victim who is a spouse, a former spouse, a child, a dependent, or other person who is considered to be a relative of the perpetrator by virtue of consanguinity or affinity, and includes cohabitational and visiting relationships. Again, important to say, but I want to go back to that definition of former spouse since it is something that is sexy in our judiciary right now. History, theory, research, praxis, experience, all of these different ways of experiencing life have taught us that the most dangerous time for a woman who is in an intimate partner relationship characterized by violence, or a person in a domestic situation characterized by violence, the most dangerous time is not when they are in the relationship, It is when they decide to leave. We had this thing we used to do again in Barbados when a woman died. We used to say, but why she didn't try to leave? Chances are, many of the women, not chances are, 99.9% of the time, women who end up dead are women who are trying to leave. Okay? Because domestic violence, intimate partner violence, they're about control and power. And when a perpetrator feels like they're losing that control and power, they try to regain it. And sometimes they feel the only way to regain that power is to stop their subject from moving, stop their subject from breathing, stop them from being able to carry any agency at all. And that is usually when violence happens, death happens. And so, former spouse is critical when you are looking at an act that is supposed to offer remedies to a victim of intimate partner violence. You cannot cover the period of the relationship and not cover the end, because, like I said, everything shows us that the end is really where we need to focus. So I just wanted to highlight that. I'm coming down the act. This thing here about domestic violence and being willful, I have pondered on it many times. It is something that I'm going to highlight to you, the legal minds. There are some perpetrators of domestic violence who do things that they don't willfully do. They do things because of their own needs, because of their own issues, because of substance abuse, because of mental health and wellness issues. I don't know necessarily, or maybe, further in the discussion, you can tell me that there's a legal meaning to that willful, but I have struggled with it and this concept of willfulness. And, what is the usefulness of having that word in this particular act? Emotional abuse is something, like I said, we brought on the act. It's no longer physical violence alone. This whole notion, though, of emotional abuse and how sometimes it is pitted against a victim, I thought it was something important to treat too. You see here where it talks about withholding a victim from access to a victim's child. Men have gotten very adept at calling for their children as a part of the continued control in a domestic situation or an intimate partner situation when the woman decides to leave. And we know that Caribbean women, again, because of the gender roles and because of how we make women feel about their responsibility to motherhood, so on and so forth, very few women will walk away if their children have to stay in a situation where they don't feel that their children are safe and comfortable. And so this whole thing of how we interpret withholding access from a victim, we switch it sometimes and we forget the very important word victim. And we start to talk about withholding a child from its father, so on and so forth, when again, experience and or situation in Barbados and the situation internationally with intimate partner violence and domestic violence will suggest that men are not usually the victims. Not that they cannot be, but they're usually not. And so when you talk about withholding and you use this part of the act to support that or whatever, just bear in mind that it is intentioned for a victim and not a perpetrator. It sounds obvious to say, but these are things that come up and things that I see. Financial abuse is the exercise of control of a perpetrator over a victim's access to financial resources through coercion, through deception, through intimidation, so on and so forth. And I will share with you a couple of years ago. Well, it is still an ongoing case, a personal experience of mine. We think of again, financial abuse as only occurring in intimate partner violence. There are many, many girl children in Barbados who face financial abuse from relatives who also molest them or who, incest, those kind of cases. And we don't have, again, a clear way, although 130A captures this concept of financial abuse, we don't have a remedy or we don't have a mechanism to deal with financial abuse. So an example is You might have a grandmother who has left an inheritance for a girl child. That girl child is experiencing violence at the hands of an uncle, at the hand of a father, so on and so forth. And that individual takes it upon themselves to change the inheritance of the child. It happens a lot in Barbadian circumstances. And then we find young women and they, they're displaced, they have children, they don't know where to go. And we kind of, oh, look at them, worthless people, get more children than they could afford, always gotta go to welfare. But when you again do the backward search into these children's lives, it is that they have been experiencing abuse that didn't start with their intimate partner abuse. It actually started with domestic violence, domestic abuse. And the research tells us that when a person experiences domestic violence in their childhood, there's a strong likelihood, it doesn't happen in all cases, but there's a strong likelihood that they will also experience intimate partner violence at other levels of their lifetime. And so this issue of financial abuse is a pet peeve of mine. The central bank is not doing enough to deal with it. Um, the Barbados Stock Exchange, because remember, when you're talking about financial abuse, it might not only be money, but it is resources. It is, and you, the lawyers, know about this housing thing in Barbados and how some estates, tie up in the court for many, many years because of these issues that are ongoing. But when you really delve down into what is causing these issues, in a lot of the cases, it is unresolved or unaddressed abusive situations. I just wanted to highlight the things that are covered under harassment. Harassment is enough reason in and of itself to get a protection order. Nobody has to hit anybody. Nobody has to, be bleeding or anything. Harassment is a thing. So think of how women are treated. And I think it was Robin last week that would have indicated a lot of women are telling us now when we do the surveys in terms of where do you go for service when you are affected by intimate partner violence and domestic violence, they're coming to lawyers first. They don't have the faith in the police. They feel like they're not being heard. They don't know what the other options are. A lot of them are going to lawyers first. And so this is a part of the reason why we have to make sure that lawyers understand. So a woman is coming and she's saying, he does tell me I can't cook. He does tell me I can't raise my children properly. He does tell me I can't clean a house. And as an attorney at law, you might be inclined to feel, well, this is not really a legal matter. But if you look back at 130A, you look at harassment, you look at the definition of emotional abuse, you understand that before hitting happens, before sexual violence happens, emotional violence is kind of like the meta violence. You have to soften a person. You have to break their self-esteem down to the point where they will accept the other types of violence, okay? So it usually starts with emotional violence in a lot of these experiences. And so if you understand that and you understand that there are provisions under the law, you might change your impression about whether it is a legal matter or not. Contacting victims by means of email, facsimile, post, telephone, text message, breaking into people's phones to get pictures that were taken at other stages of the relationship, to blackmail people. All of these are things that the act sets out clearly as breaches that a person can be held accountable for. And remember, I talked about pairing the acts together because there's a Computer Misuse Act, and it is not only supposed to be used when politicians' egos are bruised. It can also be used in a case like this to be able to bring remedy to a woman who is experiencing discomfort or to a victim who's experiencing discomfort. I wanted to go down some more and highlight hiding clothes, something as simple as that. Why are those things done? Those things are done to keep a woman financially dependent. If you go out today and you buy, let's say, $200 worth of clothes, and you get up tomorrow to put on your nice black suit that you bought for court and you can't find your suit, that is a financial loss to you. So imagine a person doing it to you over and over and over. Imagine you investing the $1,000 or the $1,500 to outfit a baby, and you get home from the hospital and you can't find a stitch of the clothes that you left for the baby. Those are things that keep a victim financially dependent. And those are the things that perpetrators do. So when you talk about hiding clothes, it seems simplistic, but when you put it into the overall cycle of abuse, it takes a different meaning. Okay? When you take up things that the victim has to use, hiding pots, hiding saucepans, discarding them. Think of you coming home every evening to your kitchen to cook and you have no pot, you have no pan. That is an instability. You can't regulate your life. You can't get the best out of your life that way. Publishing on the internet, we spoke about that one before. We have to understand what a perpetrator is, a person who commits an act of domestic violence. And like I said, we have the whole act here that outlines how those acts can be, rather how simple or rather how complex they are. And I would also say that many perpetrators don't only do one thing, it's a scale of things. And I can share those skills with you. We have developed, like, there are tools that we have. If a man does this, he will possibly also do this and that and that. And if he does X, he will also do A and B and C. And based on those scales, when a woman comes to us as an advocate, we can build what we call her risk factors. So a man who, let's say, for the 5 years that they were in a relationship, he would slap, he would tell her, you ain't good, you're useless, you can't clean a house, but he hasn't really gone past that point over a 5-year period. That is like what we see as a low risk situation. Then you might have a man who started with slapping, then he goes to choking, then he goes to choking with an instrument. That violence is violence that we're seeing as escalatory violence. So that woman is more on the medium to the high scale of risk. Then you might have a man who has lost his job, he was violent before, and now the abuse is it's what we call, it's bubbling up. So they're intense things that are happening. That is a woman that we want to get away from that situation right away. So these behaviors that you see outlined in the law, they are not unusual at all. They are a part of a pattern, and you usually see clusters of behavior in the same pattern. So I think it is also important to explain that so that you understand what behaviors are embedded in the act. It wasn't just, like I said, a man hating person who just decided me put down this, and if he's do that, and let me put down this too. It is actually a set of formula that we have developed coming out of the research and coming out of the experiences of how perpetrators behave. Physical abuse, I wanted to highlight here that it is not just what you do, it might also be what you do not do. So there are some women, and again, I'm talking about women. I've been an advocate in the Barbadian space for 20 years. I have serviced 2 men affected by intimate partner violence, and all the rest of the practice was basically women. So when I fall into saying women, women, women all the time, it is very much because it is women whose experiences I'm bringing to you as anecdotes. So several women, the man would come home, he would open all the windows, he would open all the doors, and that woman is expected to sleep at night. That is a type of abuse. Okay? So when you talk about physical abuse, it is not just the hitting, it is not just the slapping, it is also the things that perpetrators do to make individuals feel unsafe. Okay? Like I said, hiding locks, not allowing a woman to lock a door, so on and so forth. Sexual abuse now, there are a lot of cases where violences cohabit. So like I said, we don't think enough about girls in Barbados and how affected they are by domestic violence. We talk about molestation, we talk about incest, but we talk about them outside of the ambit of domestic violence. But we see here that the act allows for sexual abuse to be considered, okay, as a type of domestic violence, which means that we perhaps should be seeing a lot more protection orders for these girls in the newspaper, 15, 14, 16, 10, 8, being raped in the most violent ways by all these kinds of what I call familial relations, or at least people who are related, in some way that the act can characterize. And of course, again, you see here how the acts are supposed to work together in terms of 130A and then the Sexual Offences Act. And you put the two together to frame a remedy. A spouse, we understand that there has been an expansion there. A victim, a person against whom an act of domestic violence is committed and includes a child. Now let's pause here. I want to cross-relate this provision here about the inclusion of a child. And I want to take you back further where it categorizes child abuse and where it says that causing a child to witness physical abuse, domestic violence or intimate partner violence is in and of itself abuse. So the way that I interpret 130A as an advocate, you can tell me if you agree as an attorney, is that a child does not have to be hit in the commission of an act of domestic violence for the child to be seen as a person who is being abused. So if you have a situation characterized, a relationship characterized by intimate partner violence, and then you have a father, the mother has left, she wants to move on with her life, and he goes to the court to make a petition for access to the child. You can't tell me that you are not going to consider his abuse of the mother as a mitigating factor in whether he should have access to that child or not. Because it seems to me that that is not the intention of 130A. It seems to me that a child being in that instability, and when a perpetrator of domestic violence, when a relationship ends, unfortunately, without the right support, these individuals don't tell themselves, okay, right, let me just stop that. They look to replace their victim. They look to continue the behaviors. We also know that individuals who perpetrate intimate partner violence, they also are at higher risk of abusing children, because it has a lot to do with the way that they construct love, the way that they construct ownership. And obviously, that is not a parent who is going to offer a healthy parent-child relationship to a child. And we are not considering these things. And I think it is a part of the reason why our children in Barbados are behaving the way that they behave. Children, after all, the research will tell us, are 50% nature and 50% nurture. Okay? So I wanted to highlight to you that in the consideration of who is a victim, we have children covered. I don't think that we're paying enough attention to it. I am not talking about access and maintenance in normal cases. That's not what we're talking about here. I'm talking about access and maintenance in cases characterized by domestic violence or intimate partner violence. The visiting relationship, again, we are highlighting that, and we understand that that has to be embedded because of our historical reality and our proclivities in the Barbadian space. So we come down to the section now, the meat of the matter, where we're looking at the protection order, what it is, what it can do, so on and so forth. Subject to subsection 3 on the application for a protection order under subsection 1, the court may, where it considers that it is necessary to do so, to ensure the safety of a victim pending the hearing and determination of an application, make an interim protection order. Okay, I think these are things that lawyers need to know are available, because when a person comes and they're having a crisis situation, you have to know how you can use the law to get a crisis response. So I wanted to highlight that there is something that gives the court almost immediate action, as long as the case can be made for that immediate action to happen. I'm coming down now to page 8. The court may make an interim protection order at any time before or during the hearing of any application for an order under subsection 1, whether or not the respondent is present at the proceedings or has been given notice thereof. And again, if you understand the individuals that we're dealing with, you understand that perpetrators of domestic violence are often not rational, reasonable people. And I think one of the biggest errors that we make in the way that we approach these individuals is that we treat them as if they are rational ordinary adult human beings. And that is not usually their presentation. If you understand that domestic violence cohabits with, like I said, substance abuse, it cohabits with undiagnosed mental illness issues, undiagnosed mental wellness issues, then you understand in a lot of cases that this is not quote unquote a normal, functional human being that you're dealing with. And all of this is the way that we have to change our perception so that we are able to allow the law to do what it is supposed to do, to offer the remedies of protection and the preservation of life and limb. I am coming down to the next highlighted section. We are looking at the application. Now, we have this belief in Barbados that an application for a protection order is just a piece of paper. And really, I think if we read and understand the provisions under 130A, we understand that it is far more than just a piece of paper. Okay, so again, the spouse of the person against, these are the people that can be covered by the protection order. The spouse of the person against whom the order is sought, where an act of domestic violence was committed against that spouse or a child. And remember, we just went through the definition that says nothing has to physically happen to that child necessarily, forcing a child or exposing a child to acts of domestic violence or intimate partner violence when they are being committed is in and of itself an offense, or something that we should treat at least as in contravention of 130A if we don't want to use the word offense, because people argue that this act does not necessarily cover offenses in the legal term of the word. However you put it, though, it is important to remember that sometimes adding that child onto the protection order further protects the victim, who is usually a mother, and it also adds protection to the child, because if a child is covered under a protection order, things like access become a different creature. And sometimes it is necessary and important for access to become a different creature to protect the child, but like I said, also to protect the mother. Any other person in a domestic relationship with the person against whom the order is sought. This is important. We know that we have a problem in Barbados with elder abuse. We can think about protection orders as a part of the remedy for elder abuse. And I find that we are not doing that. But the law gives us, I think it is broad enough to give us some of the remedies that we are looking for to treat to all of these people who are abandoned here, whose pension taken away there. I think that if we reframe it, well, not really reframe it, but use the act to do what it is setting out that it can do, we are able to bring remedies to those individuals as well, who are usually female. A person other than the person mentioned, okay, so we're talking here about who can apply for the protection order in support of a victim, okay? And I know there are a lot of lawyers, nobody in this room, of course, who are very upset, I guess you could use that word, about the services that I offer to victims as an advocate. But just to note that representatives of non-governmental organizations who render support to domestic violence victims are also included as one of the categories of people who can support victims. Okay, now when we come to the discussion section, I have never found out how to take leave of the court. So if somebody wants to tell me what that means and how you do it, I guess that is another little tool that I would be happy to have. You always have to make sure that you are getting the permission of your victim. You can't work for a victim. You work on behalf of one. You work in collaboration with one, but you can't move beyond your victim. But just before we get to that, let me just make the point as well that child care officers and welfare officers have responsibilities to children. So then you wonder why sometimes women will go into the welfare department, and after doing the workup, the welfare officer will be well aware that that woman is coming for state service because she is in an abusive situation and trying to get away or being deprived of resource. but I don't see any protection orders being triggered at that level, right? So, when you think about the act and you think about the system around the act, we have a real deep seated problem in Barbados. And I really don't know how we are going to, I don't know what the overarching solution is, but I just know that we have to continue talking, training, and agitating because the lives of people depend on it. That's just the long and short of the reality of the thing. All right, so I think it is the next point that I have highlighted in yellow that right. So yeah, it's the next point where you're actually seeing that a victim never loses their agency. Okay, this act is set up to bring remedy to the victim, but you can't work above and beyond or outside of your victim. And I think that's one of the things sometimes that attorneys at law, I don't know if it's a secret or not. If it is, I apologize because I'm telling it. I would have done a lot of work with Talal Nome around domestic violence and intimate partner violence in Barbados. And I think sometimes that's where it gets hard for people who are really committed to the work, because sometimes you feel like you want to act on somebody's behalf. You really just want to yank up this woman and these two children and bring them to safety. But unfortunately, you have to go as quickly as your victim. You can't go quicker than them. And hopefully, in a lot of cases, we also go slower than them. We need to stop that too. But we definitely can't go more quickly than they're willing to. And I always tell Talal will hear me say this over and over again. I do not bring a woman out of a situation until she is ready to come out. Because again, statistics will tell you the more that woman leaves and goes back, leaves and goes back, leaves and goes back, there's a higher likelihood that she will come away from the situation without her life or with loss of limb. So it is very important to make sure this agency part is not just even to make sure that a victim's voice is always heard, but it is also a security issue. All right. I'm struggling to keep up with the two screens, forgive me. Okay, so people say that, women can just abuse this act, they just use it when they're vexed, they just do as they please. And I just wanted to point out that there are also ways in which the act speaks to, abuses that can occur under the act. Okay? It also gives the court a timeline. The only time that I have ever seen this timeline honored in Barbados is during COVID. Like it worked like a dream during COVID. And I think a lot of that had to do with the fact that only District A was hearing protection orders. So I think the removal of the decentralization helped in that period of time. I am not in the space now, so I don't know if this today thing is working now, but it has always been something that we've been falling outside of. I will admit sometimes we don't fall outside of it by a lot, but at the same time, if we understand the urgency of a lot of these situations, we really should be striving not to fall outside of it at all. And in some cases, to make it a same day process or a 24-hour process at least. Okay, so the forms of a protection order. So we're getting even further into that whole conversation about the protection order not just being a piece of paper. Your protection order can do a number of things, okay? It can be just an order that says, okay, you two need a cooling period, you go that way, you go that way, or it can be a lot more complicated than that if the situation deems or deserves it to be more complicated than that, okay? So subject to this act, a protection order may include provisions restraining the respondent from being on the premises on which the complainant for the protection order or the child in respect of whom the order was made resides. So we have this way in Barbados where we are still putting women and children out of houses for being victims. I have a problem with it. And the reason I have a problem with it, and I'm sorry, but this is the way I feel, it costs a whole lot less to move a perpetrator out of a household and leave the victims in the household than the other way around. Every time that I have a woman who is affected by intimate partner violence and I have to go and push her in a shelter and I have to find spaces for 3 children and I have to transfer the children from St. Michael down to St. Lucie because I'm trying to tuck her into a hidey hole. If you look at the amount of resource, not only state resource, but sometimes NGO money as well, it takes to replace one victim of intimate partner violence, it is cheaper to move the perpetrator and to treat the perpetrator and then try to reintegrate him somewhere else than to continue moving victims. Okay, so I wasn't sure if we understood that the law made provisions for victims to stay, but I wanted to highlight it because we seem to feel that the victims are the ones who are to move. And I don't think that that is, again, the spirit. It is definitely not the international best practice as we would have gone through last week with Sarah. Causing another person to engage, I wanted to highlight this because sometimes we don't understand the extent to which men go. And when women talk about their experiences, we tend to make it seem as though they're embellishing or they're picking at little things or whatever. But there are men who, let's use the example of the cell phone, because that has changed the whole dynamic since it has come about. Will call a woman 60 times a day, 100 times a day, 200 times a day. I have a pile of email that I once got from a woman. I mean, like a pile, like a ream of paper worth of emails. And then when she stopped all forms of communication with him, he would send his mother, he would send his sister, he would send his best friend, he would send his pastor. And I want us to be clear that all of that is behavior that we anticipate, is behavior that we understand we will see in these situations, and is behavior that is covered under the acts and the act and provisions. Okay. Robin, just show me the page. I skipped. I'm sorry. What page are we?
Page 13.
Okay, thanks. All right. So there's a few things here that I wanted to highlight. Right. So all of these things the protection order can do. And I think it is important to really study this section, to really understand it. This section can really enable a woman to step past a situation of abuse and move on and right her life, or to be continually sucked in. There's a particular case that I have been working on now. The child is 8. All 8 years that child and mother have been through in and out of the court over access and maintenance. And when you really get to the crux of what happened, a protection order that treated to the issue of access and maintenance really should have been triggered at the beginning of the situation, and it would have saved that mother those 8 years in court. A protection order is not just a piece of paper. It is a remedy for a victim to be able to step outside of the cycle of abuse. And abuse is cyclic. It is not, we're not talking about the one time where a man gets vexed and throw 2 loose words at a woman. That is not what domestic violence is. That is not what intimate partner violence is. You are talking about generational, continuous, historically long events. Okay, in my case with the financial abuse, you're talking about somebody that forged my signature for 30 years. This is not a one-off incident. It is not something that is caused by vexation. And I think this again is how we have to understand the meat of what domestic violence is, and then what the law is trying to do to be able to get people or to help people step beyond the abuse. So a protection order may require the respondent to leave the premises. That's the most basic thing. not only is he to leave the premises, but he has an obligation to maintain the children that are there, to maintain rent, to maintain mortgage, to maintain utilities. We make women feel as though these things cannot happen. But at the end of the day, the law is telling us these things can happen. It can allow the complainant to enter and remain on the premises. Okay? I think this is important. Again, this is one that I am not seeing enough of. A woman has to leave work, go to the doctor, eye bust up, foot got soft tissue injury. I have seen a woman who lost eyesight because of an issue of domestic violence. And women are not getting losses. Okay? And you need to make sure that these are the things that your protection order pays attention to when you take your client to court. Okay? Acts of domestic violence, when somebody, like I said, take all your clothes and soak them with kerosene and attempt to light them or whatever, but you can't use back your clothes. That has a value. Okay? Your loss of earnings. Some women are, for weeks at a time, they can't go outside because they fear for their life, or they're too injured to go outside. All of that has a cost. Because of, if they do have to leave, and this one would help me significantly, if they do have to leave, then that man has a cost to bear in terms of accommodation. We are talking about the women at welfare, and we get vexed with them for going for welfare. But in a lot of cases, they have to do that only because the legal provisions that are inside the act for them not to have to go are not being taken up. Okay? Make payments to the complainant for the maintenance of a dependent. This is important. Like I said, a lot of this court time that is being used to adjudicate access and maintenance in Barbados can be avoided if we make sure that the protection orders speak to the issue of maintenance and access right up front. Do not even let it become a weapon for anybody to use. Just make sure that maintenance and access are conditioned inside of the protection order. That is the intention of the law, not even just, spirit, not even just spirit, because it is set out. So I would say it is the intention. I want to talk about custody as well, because that is important. We are not allowing women the agency, the permission to step outside. I remember one time I had a woman, her former intimate partner had attacked her brother and her current intimate partner with a cutlass. They were defending her, okay? And then he took their two young children. There were two girls, I think 7 and 9 or 6 and 7. I don't remember the ages. And he took those children at his house and locked off the woman's children in his house. And the lady called the police to be able to get the children back. And the police told her, we can't get in that. That is man, woman thing, we can't get in that. You are leaving two children under the age of 10 with a man who was charged for assaulting two other grown men with a cutlass. That cannot sound right to anybody. Okay? So it is important sometimes where no order is enforced under Part 3 of the Maintenance Act, with respect to legal custody of a child of the respondent, of the Minors Act, of Part 5 of the Family Law Act, Cap 214, with respect to custody of or access to a child of the respondent, grant custody to who? The complainant or such other person as the court specifies. Now that or such other person as the court specifies, I once saw that provision used to give custody to the paternal grandmother of a man who had just murdered a child's mother. I have seen this act do some of all kinds of things in Barbados. Okay, let me just say that. But I believe that if you understand what domestic violence is, it is easier to interpret the act and the intentions of the act. When you remove a woman and you grant her a protection order from a cutlass wielding man, but you leave an access arrangement in place that puts two girl children in his care under the age of 10, you have not done anything to break the cycle of abuse. You have not done anything to interrupt that problem at the community level or at the national level, all you are doing is creating a girl child who will possibly end up facing that same type of instability in her own life cycle with her intimate partner. That is just the reality of where we are. That is the reality of how this law interacts with all of the practice that we were talking about in the last sessions prior. Um, I'm coming here and I want to highlight, so it's the custody. There is a provision that allows for firearms to be removed from men who, I'm sorry, from perpetrators who uh, engage in domestic violence or intimate partner violence. Now, this doesn't help us in Barbados a lot because a lot of the guns in Barbados are illegal. Okay, and there are no ways for the police or for lawyers or for whoever to remove the illegal guns from the home, and there are a lot. And there are a lot of women who are very afraid of the illegal guns in the home. But at least in the spirit of the law, we recognize that if you have a person who is volatile, the person is, you're not dealing with a normal, rational, healthy human being. There is some volatility. Then if there are any licensed firearms in the home, you need to consider that. I think we also need to consider the illegal ones, but that is something that I don't have an answer for right now either. Okay, so a protection order that includes a provision mentioned in paragraph A of section 1 may also include a provision to restrain the respondent from taking possession of personal property of either the complainant or the respondent, being property that is reasonably needed by a member of the respondent's household. So I have seen, for example, you know, and I can only tell you what happens. I can only tell you what women that I work with experience. I have seen police, they escort a woman from a property. She doesn't want to be there anymore. She's afraid, whatever, whatever. They tell her, well, hurry up quick because I can't stick up here too long. Hurry up quick. And the woman grabs whatever few pieces of things she can grab, but school uniforms are left. Okay? Computers are left that children need to do homework on. All kinds of things that that woman will need to resettle her life are left. And then when she goes to the police and she says, well, look, I need to get back this property. Oh, you only miss the man now. You only want an excuse to get back up there. All these kind of things. All right. And the act is clearly anticipating that these things will happen and giving attorneys at law remedies that they can make sure that victims don't have to be dealing with these kinds of things on ongoing basis. Uniforms in Barbados cost a lot of money. I don't know who's ever had to do that shopping, but it's not cheap. And if you have to run from, you know, one situation 3 or 4 times, research again will tell us women will leave 1 to 2 times before they actually leave. Anything more than that is dangerous, but 1 to 2 times. So you're leaving uniforms and having to buy them back and having to hide uniforms at your mother house when you go up there and all of that 1 to 2 times in a child's life. That's a lot of money. Okay. Directing the respondent to give permission of such property as is specified in the order or specified to the member of the respondent's household. We need to understand prohibiting the respondent from damaging property. So again, I have seen men who cut up clothes, you come back the next day, chairs destroyed, table mash up, all of this kind of thing. There is provision for that. And there's also provision for costs if those things happen. So all of these are things that we have to begin to really think about and understand and make sure that when we ask, well, why she didn't leave, that we have given her the best chance of leaving that we can possibly give. A protection order shall in each case provide the respondent against whom the order was sought to attend the Family Services Division of the Welfare Department. It's actually written in. You wouldn't believe that these things are written into this act, given the way we treat to these issues on a daily basis in the courts of Barbados. But if you have a protection order, the order sets out what is supposed to happen to the respondent. That family services program is one that we had talked about a couple of weeks ago it no longer functions as far as I know. There was, like Lani had said, some discussion about, reviving it, whatever the case may be. I don't think it has happened. But the act provides. The act also provides for a woman to receive counseling. Now, let me say that we have this very bad practice. It's not international best practice to ask women to mediate with perpetrators. You cannot mediate with an individual who is not a reasonable, rational human being. When you have a perpetrator of domestic violence, one of the characteristics of a perpetrator is wanting control of a victim. When you open up a mediation session with that individual, their intention is to use that session to regain the control that they feel that they have lost. There is no such thing as negotiation with a perpetrator of domestic violence because of the way that they construct all kinds of things, men, women, um, their obsessiveness, their possessiveness, again, the way that they treat to control and that type of thing. Mediation does nothing in circumstances like these. And remember, the act talks about holding people accountable, building solid boundaries. A part of the reasons why intimate partner violence and domestic violence happens is because of blurry boundaries. Okay? Mediation, by the very nature of what it is, requires blurry boundaries. And so it doesn't work for a situation where you're actually solidifying boundaries and not blurring them. And there is an interpretation sometimes that when women don't want to do mediation, that the woman, she bet, she bitter, she this, she that. No, because I'm going to tell my victim right up front, do not agree to mediation in court, because that is what international best practice is telling me. And that is what experience, not only in Barbados, but again, across the world, in the worldwide pandemic of domestic violence, is telling us. So don't ask women to do it. It does not work. Okay? I would ask, again, as we look through the sessions about what the Family Services Division is supposed to do and the counseling and so on and so forth, do we have the capacity to do these things in Barbados? And if we don't have the capacity to do it, then again, my humble suggestion is perhaps the way that our society is constructed, when the lawyers come out and say, well, listen, we need these things to work for us to be able to move these things through court faster, probably they will listen to it and be more receptive to it coming from attorneys at law or whatever than they have been over the years with it coming from advocates, right? Children, again, are all supposed to be getting their counseling, so on and so forth. We don't have the money. But you can see as you go down into 7, the government has clear responsibilities. Things, like I said, that we have accepted UN money and UN responsibility to do. Okay, but that we are not doing. And this is just the state of play. All right, so remember I said that we, in order to treat to the issue of how the police view their duties, we actually have duties set out for the police officers, which I'm just going to skim through because this is not training for police, but just for lawyers to know that the act sets out particular things that police in Barbados are supposed to do. So, 11A, that whole section, there are things that police are supposed to be doing, and it helps for you to know that. I always make sure, especially in cases where there's non-physical violence, so there is not a way for me to get another record, there will not be a doctor's report, or there's not a witness or whatever, I will take my victim to the police station and I will insist that the police take a statement from the victim, okay? Because that statement becomes then a record. And where you have 4 or 5 or 6 of them, they can still help down the road in terms of the securing the protection order. So making sure that the police take statements, they're supposed to do it. It is outlined in the law. Making sure that your victim also gets statements. Making sure that they get reports of the domestic violence. Continue on, Robin. All of that is outlined. Where practicable, I lean on this section a lot to make the police do what they are supposed to do. Because at the end of the day, I understand that women go to lawyers as a first port of call, but the lawyers don't have the same powers that police do. And so I lean on this section a lot to make sure that police do sometimes the things that they are supposed to do. Okay? Accompanying victims onto premises, looking after welfare of children, a lot of the themes that we have spoken to before. I just wanted to highlight that there is a power to issue an emergency protection order. Again, because of the volatility of these situations, you need to do this in some cases to be able to preserve life and limb. I was talking earlier about an escalated perpetrator. An escalated perpetrator is one who is at the height of his cycle, at the height of his instability. And really, the only way to be able to manage that situation is to help that person to manage the boundaries. Otherwise, they do things that end up being detrimental for them and victims as well. So if you don't want to see it as helping the woman, see it as helping the man. Because if you stop a man from blowing up his house with his two children inside of it, you're not only helping the mother of those children, you're also helping the person who has the capacity to commit an act like that. When you stop a man from again lighting, two women and a baby in a house, if you don't see it as protecting the woman, see it as protecting him. See it as stopping a child from being fatherless. However you have to construct it, but you can use this power of emergency protection order to be able to bring management to an escalated perpetrator. And just like I was saying here, if you can't do it for the woman, the welfare of any child residing with the perpetrator or the person at risk is one of the things that you can use as a determining factor in an emergency protection order. So the act is not looking to give power to women, it is looking to make sure that vulnerable people can be offered remedies too. All right, now we're going right down. A member of the police force may arrest without warrant a person. So if the police walk into a volatile situation, they don't just tell them, man, you two want to need to go and have some good sex and figure it out. All of these are experiences that I have had. The police actually have a mechanism to make sure that somebody leaves that premises with them to make sure that that situation does not become one where life or limb is lost. Okay, so I'm not saying these things, lawyers can't do the same things, but at least lawyers can advise their clients and make sure that everybody is clear, that everybody knows that these are some of the provisions within the order. The obligation to report child abuse, forget it. Every welfare officer in Barbados got to pay a fine. Every child care board officer, every doctor, so many people, every teacher. Like, we just don't do this, okay? Nobody is reporting the child abuse that comes out of these situations. Nobody is protecting the children. But then we wonder why we are having such issues with young people in the society and the bullying, like I said, and the opting out to be on the block. But I will tell you one time what one of the I guess you could say name brand criminals in Barbados told me, by the time you done watch your mother mouth get burst, and by 8 you realize you fighting with this man, but you can't protect your mother and this and that, whatever. It becomes easier to do anything that you gotta do as a man after that, because there is no feeling of safety that you could ever have anymore. There's no feeling of worth, so your life pretty much just spirals. Okay, and that is really what we are talking about in terms of the way that domestic violence doesn't only affect a person, but affects an entire community. So a person who is aware or has reasonable cause to suspect that a child is a victim of domestic violence, remembering that that doesn't just mean that they're being beaten or whatever, but that they're experiencing this violence, even just being in the situation, they have a responsibility under the act. That never, ever, ever happens. Never heard of a case. And then the final aspects of the act are just the forms that are supposed to be used. Some that you might be familiar with as attorneys at law, and some that you probably never even saw before, but because we just are not using them. So I just wanted, I know it was a lot, but I hope that it was useful to go through it. And I will now open up to receive questions or comments on this session. Thank you very much. Robin, everybody left?
No, they're here. And feel free to pop questions in the chat if you prefer, or just unmute your mic.
Hey, Marsha, Talal, Noma here.
Hey.
I just want to say thank you again for this lovely session. I prefer the law rather than anything else. But I just want to drop a comment, and I think most people could appreciate, the attorneys especially, when Marsha, no offense to you, but you keep saying she. It's also he. You know, because the Protection Order Amendment Act also falls into gender neutrality. That's the whole point. I mean, up to today, Marsha, I haven't spoken to you about this, but up to today, I had a wife lock her husband inside of a house after making threats to burn down the house. The police were called and nothing happened. Nothing happened. You know, so although I appreciate that when we look at it, we say she, it's also he, you know, and I would really prefer that if everybody would contribute to this by saying they, you know, both he and she, because at the end of the day, although majority of the perpetrators, I would say 85 to 95 to 99% of the time are men, it's still the women, you know, and we have to drop the gauntlet equally between both, because what a man can afford and write the same as a woman, or the vice versa. That's all I have to say.
Thank you so much for that, Talal. No, I take the calling out. You know, I used to joke and I used to say up to 2019, I had never dealt with a man who had experienced intimate partner violence. But like I said, and I did say in the presentation, I don't know where you joined, but I have since dealt with two cases where men were victims, one which you and I did together. And so, you know, there is a real way. And if you're telling me there's another one today, no, you know, that is triggering me because I want to understand what is causing that. It might be something as simple as the roles reverse, because like I said, domestic violence and intimate partner violence have nothing to do with a horn. They have nothing to do with who get who vexed. It really is just a power and control issue. And as we see women assuming roles in society where they have money, they have houses, you know, they have the instruments of control, as you call them, it really might be just, you know, the thing turning itself because of the factors that cause domestic violence. So I will take the calling out, and I will definitely try to use more they language than she language moving forward. Thanks for that.
But you know, like while you say that, I mean, in Barbados, it's prevalent more. The abuser, the perpetrator, is the male. You know, very rarely, very seldom do you find a man filing for a protection order against a female. Very seldom. I've had that in my practice of 12 plus years, like one.
Yeah.
You know, and I'm sure all the attorneys, Miss Evans, I'm going to call you out, Miss Daisley, they can say it's majorities, always the applicant is the female. But I think if we are going to take a sensible approach and we're turning this world into a different dimension where, you know, we're forward thinking, we got to think forward thinking and not only think just male or just female, but they rather than he or she. But that's just my opinion. Japter Ince dropped a comment. If you can address that, Marsha.
Okay, sure. And Travi has their hand up. Travi, am I saying it right? My apologies if I'm not, but go ahead.
Yes, that's correct. Thank you. Good evening to all. I'm not an attorney, and neither do I desire to be. This opportunity was extended to me by an attorney, and I'm just, as I mentioned to her, sometimes I feel out of my league. I'm a barber, and I'm into retail. And being in the barbershops, you hear conversations, you hear experiences. And, you know, for those listening in, sometimes you're laughing, but it's not funny. The realities that are out there and the experiences people get when they need legal help. But I'm learning so much, and just wanting to say to you guys, I'm grateful that I'm hearing that there are attorneys out there that care. I'm grateful that I'm hearing there is hope and there's help, but due to lack of knowledge, I mean, I'm guilty of talking some of the ignorance that we help to spread in the barbershop and in other places. So the last time, forgive me, folks, I didn't, when I said the $sign, I meant for for attorneys. I did not hear you guys saying, oh, people coming to us and they didn't have the money. I'm hearing people saying, we want to help. We want to bring change to the, I've been learning some word, judiciary and the magistracy and all these, you know, and I'm going to help to change the conversations now that I have been learning and hearing, you know, from this side. And I'm kind of wishing that more of us in certain settings could hear this, so it would break down those walls, you know, those ignorant mindsets that we carry. So thank you. Do forgive my foul ups. It has been thus far a most interesting learning experience, and I'm looking forward to more.
Thank you so much. All right. So,
Marsha, can I respond to that, please?
Yep, go ahead. And then
Yeah,
I will
I
handle,
appreciate that comment, and I say that I accept that comment and what you said to all us attorneys at the bar. You know, there's many attorneys that are sitting right now watching this, and all I have to say to that is I'm glad that you have been enlightened, because at the end of the day, for all of us, it's not about the money. It is not about the money. We make money left, right, and center. It is not about the money. In Barbados, all persons that are aggrieved by anybody, by a respondent in a matter, they can.
Somebody needs
Hello?
to turn their mic off. Somebody.
Yeah, like I was saying, I say this across the board to all us on behalf of the attorneys. It's not about the money. We're not here to make money. We do not make money when it comes to these kind of matters. You know, anyone who is aggrieved, who is not in a financial position to pay for their legal affairs, can go to community legal services. We don't get paid that much. Trust me, we do not get paid that much. And I say that on behalf of all the attorneys that are listening. And if they want to disagree, well, call me, because we don't get paid that much. And it's not about getting paid. At the end of the day, community legal services is almost like pro bono, but you can't call it pro bono because we're still a dent on the public purse. The government still has to pay us. So although we say pro bono, it's not pro bono. It's still time from our legal time, or the money that we expend, the expenses that we expend, and taking instructions, sitting down with clients, etc., etc. It's not about the money.
The only thing
Once you
that I would
appreciate that,
beg though, thing that I would beg though, Talal, I would like to see attorneys in Barbados doing more. Rashad had a fancy word for it, but taking the cases that are difficult and turning them into precedent. I think we need a lot more of that in Barbados to help our situation. We have been having the conversation about Lalou's case and the Chief Justice and taking it to the CCJ. I hope that is his intention. And I understand and I hear what you're saying about the money, so on and so forth. But I just hope, perhaps from this experience, perhaps from other experiences, that attorneys in Barbados also consider the ways in which the law can be used to turn the cultural tide, for the lack of a better word. So we need more litigation. I think he called it intentional litigation or strategic litigation or something like that, but it is important. To answer the question from Jeptra about
if I could add that before you answer,
quick, Talal, because I want to answer
really quick. I know
Mm.
we're limited on time. 20 years ago, from what I understood, Barbados, the community legal services used to pay attorneys at law by whatever they taxed, right? They move now to a fixed scale of how they pay attorneys at law. Now, for us, it's not, money's not the end all or whatever, but at the end of the day, it is a factor. So if the judicial commission, whatever, whoever governs how the attorneys are paid through legal aid, I'm sure some attorneys could agree with me, if we can move it to a scale that it's fixed in the high court, but if you take it to appeal, it's different. That is thought for consideration, because it's not that it would give lawyers a reason to proceed or to pursue a matter, but it would pay their worth, because we went through hell through law school. So yeah, that's all I have to say.
Yeah. Well, I mean, I
Moving
hear
on to
it,
chapter
Talal.
ends.
20 years of 20 years of a career that I didn't get paid for. Trust me, I understand about wanting to be paid your worth, but I guess it is what it is. In terms of Jepter, with the question about safe housing for men, we only have one shelter on the island of Barbados. One. That shelter is run by the Barbados Professional Women's Club, a non-governmental organization, and the shelter is predominantly for female victims. One of the pet peeves that I have about this space, and I would have expressed this to them so I can say it publicly, it doesn't even take boys over 13. And as I said before, anytime you're trying to offer a remedy to a Barbadian woman that involves separating her from her children, chances are that's not going to be a remedy at all. So, do we have safe housing for men? We do not. We don't even really have safe housing for women in Barbados. This is something that the government of Barbados has to pay attention to. I would have spoken about the model that I'm trying to develop for Barbados, where we move away from thinking of safe housing as sheltering. Sheltering cannot work in the context of Barbados because of our size. What we need to think of is the way that we can distribute safe spaces across the island for individuals who need safe spacing. I am going to say, in terms of sometimes we might not only need safe space for men who are victims, we definitely also need safe space for men who are perpetrators. And that will require us to think about the cohabiting issues that they have, issues with substance abuse, issues with mental health, whether it's wellness or illness, so on and so forth. So if we think of housing for perpetrators as well, that is useful, because all of that is taking the responsibility away from the victim to be able to manage. So safe space is definitely one of the things that we are not doing quite right, in my humble opinion, in Barbados, for women, for men, perpetrators, whatever the presentation may be. So that's my answer to that question. Any other questions or comments?
Marsha, we also talked about going back to the concept of willfulness as well.
Right. Yes. I wondered if the attorneys could tell me what is the legal, what that willful in that particular space where I highlighted it, what does that mean? Why is it there? I don't know if you can pull it back up quickly, Robin.
Yep, go into it.
Yes, and then also, how does an advocate take leave of the court? Bearing in mind that this process, one of the things that this act was supposed to do was to make the filing of a protection order, it was supposed to move it from beyond the services of an attorney at law to make it more accessible for a wider cross section of women in Barbados. So if bearing that in mind as well, I just wondered, how does an average citizen take leave of the court? So while you're thinking about those two things, or if anybody wants to take me up or not, Jepter is asking how many of these cases do we have on average in Barbados? Which cases are we talking about? Again, I would have indicated that one of the things that we are not doing in Barbados is keeping a national registry of our domestic violence, intimate partner violence, and sexual violence cases. So we really do not know what our pandemics look like in Barbados. We do not know how many women are affected. We do not know how many men are affected. We do not know how many children are affected. We are not keeping the statistics. And this is an important part. It is why Barbados could not tap into the, I think it was 30 or $40 million that the Spotlight Initiative is sharing out between the UN and the European Union across the Caribbean region. And we haven't done anything to rectify it. So we need a national statistical bank for domestic violence, intimate partner violence, and sexual violence. And once we have that, then we are able to understand how many cases we have. But I'm not getting into any discussion. I take Talal's point of, neutralizing the language, but I'm not getting into any tussle about proving that men experience domestic violence and women. And I'm not getting into that tussle because the statistics tell us gender-based violence is still an issue that disproportionately affects women and girls, not only in the Caribbean, but across the world. So it is not useful to talk about men or ask what about the men instead of expending our energy to be able to deal with this as the national crisis that it is. As much as women are being affected and as much as men are being affected, children are being affected even more so than those two categories. And I think it is causing a lot of the instability in our children's behaviors that we are seeing. So I think we should also think about, how we can protect our children. Any other comments? Any other questions? I'm just going to pick on Talal and ask him about that willful and taking leave of the court, because he's probably the only person that's going to answer me. Is he there?
Marsha, what was your question?
Okay, so look at page 5. Domestic violence means the willful infliction. And I was saying that in some cases, as we know, where you have a person who is affected, for example, by mental health or mental illness issues or whatever, this question of the willfulness is, I've pondered about it. I've pondered about the usefulness of that word there. So I just wanted to know, if there was like a legal reason it was there or whatever. I just wonder about it.
Well, I could be corrected if I'm wrong by my other colleagues that are probably in the chat. But from willfulness, what I understand that to be is that it means the willful. The person, the other side, has to consent to it, and most of the time they don't. So
the willful infliction
or
of harm by one person.
Willful. Oh God, how can willful infliction?
Exactly. That's what I'm saying. Like, a lot of this violence is, I mean, it goes back to this thing that we want to do with our law of blaming people and making people right and wrong. Sometimes it's just complex, right? Hurt people. And so, I mean, whatever. I know willful means intentional, but how do you, in the context of, let's say a man is coming home every night and, I don't know, skinning up all the pots and telling the woman how she don't do the house properly, this and that, or whatever, but he does it under the influence of alcohol. Like, I don't know, that word willful to me is like, I just don't know why it is there, but it's not, I mean, whatever. I just wondered about it. And then how does an advocate take leave of the court?
Wait, Marsha, before we go on, both Raquel and Shane have entered information into the chat. I don't know if you want to read them out for everybody.
Yeah, no, they're saying willful in legal terms means doing something voluntarily that you know is unlawful. Ah, that makes sense. Okay, thank you very much for that. Okay, mental illness may mean that the person is not doing it voluntarily, therefore they may not be considered as willful perpetrators. I see. Okay. All right. Thank you. I will ponder on that because again, now, if we understand the way that domestic violence cohabits with mental health and wellness issues, then it means that that word willful is even more problematic than I was anticipating it to be. Mental illness is a legitimate defense. Yes, it is. Yes, it is. All right, okay. I don't have an answer for it, but now that I see where the reasoning behind it was, I can think and research and try to understand it a little more. And Robin, if you can find the one about taking leave of the court. There's just bits and pieces of niggling things that I never quite reconciled. Right. So a person other than the person mentioned in paragraph A or C as an agent of the victim of domestic violence, including a social worker, probation officer, or representative of a non-governmental organization which renders support services to victims of domestic violence, where that person has obtained leave of the court.
And sorry, Marsha, before we go on to that, I just also want to point out Raquel's further comment, which is, but drunkenness is not a legitimate.
It's not a legitimate defense. Yeah, I see that. Mm-hmm.
We all agree.
Well. But although mental illness needs, wellness needs are a legitimate or defense as well, you might still want to institute the protection order. That's just I just feel like that word willful needs to go, but that's just my feeling. And like I said, I'll do some more research. I'll do some more reflection. Now that I finally get the context, I can talk to some more advocates in other spaces and hear what they're thinking. Taking leave of the court, Talal, as a lowly non-lawyer. This one here, a person who is basically acting with the permission of the victim, but is not the victim. You can act on behalf of the victim, but you have to take leave of the court.
In my opinion, for years, or from what I understand, and again, I can be corrected by attorneys across the board on this platform, but a friend of the court is a friend of the court. And, you know, years ago, when I first came to Barbados in 2008, I sat in a courtroom before Pamela Beckles in the magistrate court. And a senior asked me, hold in this matter. You're just an attorney in waiting, whatever your case is, right? And I got up before Pamela Beckles and I said, I would like to cross-examine. And she said, no, you can't. And I said, as a friend to the court, and everyone could laugh there. I know they're all laughing at me, right? But I got up and said, I'm ready to cross-examine as a friend to the court. And she said, I accept that, but I think it's best that the lead counsel in the matter take suit. That's in a criminal matter, and I could appreciate that, where, you know, you're not a lawyer, so STFU and sit down. But in relation to domestic matters, I believe in relation to that subsection D, if you're an agent of an individual before the court, then why not? And I know, I understand you, Marsha. I don't know, correct me if I'm wrong, that you went before the court and said that I am acting as an agent, as, you know, the voice of this individual, and you got shut down.
Oh, no.
Shut down more than once.
Standard.
You know, and I
I
grounds of appeal, if you're asking me.
You know. Anyway, the discussion in the chat is very interesting. We have a doctor who has weighed in about the whole notion of mental illness and you know, using it as a defense. And I think really and truly this kind of cross discussion is, when I envision this course, this is a dream that is manifesting, because it really is, okay, how do each of us throw our hat in the ring to come up with an overall solution that can save lives and stop instability in our society? Um, but yeah, I'm glad to see another attorney saying that the willful is problematic. I just think it comes out, like I said, of that colonial relic of wanting law to be a simple case of who is right and who is wrong. And I think when we're dealing with things as complex as these issues, it's never really who is right or wrong. It's really just how to, like I said, create remedies that support the majority of people in the widest way. If there are no further comments or questions, we didn't have a break inside of the session, so I am quite happy to leave you with the other couple of minutes to get to other things if there are
Just
no.
one comment, if I may, Ms. Hinds, one comment, yeah? And I've said this time and before, and I keep saying this over and over. And all the attorneys that are sitting here can understand what I'm saying by this, what I'm about to say. Our adjudicators need to be trained, because every time we go before a certain adjudicator in a protection order, domestic violence amendment act application, we are met with characters. We are met with characters that sit down and, you know, they take their opinion from the start and from how they prefer to adjudicate from their opinion. They need to be adjudicated more and more. And earlier, like 2 or 3 sessions ago, the ones that I made, I missed some. I keep saying that the police need to be educated on this, and they're not. And it's a cycle that we just keep going over and over. Lovely, Barbados amended the Protection whatever act. We amended it, lovely, great. They don't get it. They don't understand it. And it has to come from all aspects of how matters are adjudicated. From the adjudicator, the magistrate who's going to hear the matter, from the police who have inception of the matter, from the attorneys who have conduct of the matter. We got to do better, you know? And I just feel like, you know, change the law is lovely. That's great. Fabulous. That sounds good. Amazing on paper. But at the end of the day, when you go to court and you got to deal with it, that's a different story. It's a different ball game. That's all I got to say.
Yeah. No, I definitely thought I was a lot wetter behind the ears when I said, like I said, I saw veterans fighting for this law, fighting for it as if it was the end of, you know, the domestic violence and intimate partner violence crisis that we had in Barbados. And when I saw their passion and I saw the strategy and everything, I could have never foreseen what would have happened, where they got this really comprehensive piece of legislation on the books of Barbados, only for it to be ignored and disregarded. And like I said, that ruling that the Chief Justice made the other day about former having a limitation, it is little things like that that seem benign that can stand between a woman and her life. And so this whole experience of the 2016 amendments to 130A have shown me that as advocates, we can't put our faith in legal change alone, because legal change without cultural change leaves us in the position that we are in now. You know, it's sad. It's sad, and women are falling in Barbados. Women are being maimed and injured in Barbados, and I'm sorry, people, persons, individuals. I'm correcting myself, Talal. I'm getting into it. And we're not paying attention. You know, it's concerning. Jacta was asking a question about why not use the OAPA instead of the DVA where there is physical abuse. I don't know what those acronyms stand for. You would have to edify me on what the acronyms are.
Right. Good evening. Or APA, offenses against the person. I was just wondering why when there's physical abuse, why the police don't charge.
But that's what I keep trying to tell police in Barbados, and again they resist it. They tell you that you can either get a remedy under 130A or under another act. And I'm telling them, no, you can get remedies under both of the acts. Use them together. It shouldn't even be either or. The acts need to be used in conjunction with each other to give the strongest remedy. So it's not an either or, because the two things that the acts treat to are parallel but separate issues. So they need to use 130A and they need to use the other piece of legislation. That's how the legislation was intended to work. It's not a standalone piece of legislation, because domestic violence, as you all know, in the Barbadian space, is not a crime in and of itself. But there are crimes that are committed along with or because domestic violence is being perpetrated. So it needs to be a coherent approach. Use both, not even an either or. It needs to be both.
And I just want to highlight that Raquel went on to say about the fact that she went to court under the DVA with a male, and that was her first DVA in Barbados, and she was laughed out of the court. The clerks laughed, the police laughed. And Nyla also mentions that she agrees that that willful should be removed as well. Whatever the mental state of the perpetrator, if they commit a wrong, the victim needs to be protected.
Yeah.
The need for protection does not decrease if the perpetrator is not mentally competent. In fact, I would think it increases.
It increases, exactly. Yes, absolutely. And we also need a mechanism in Barbados to, you know, that we don't deal with mental health well on the face of it. Salam knows the case that I am talking about. There are two sisters who are living with a brother who is not mentally, something is not right. Like, you know, I'm not diagnosing anybody, but there's a mental wellness or illness issue or something, and he is wreaking havoc on the lives of those two women. And they have just been getting protection order after protection order after protection order from the court for about 6 years now. A protection order in that matter cannot solve the matter. That matter needs a deeper remedy. Somebody, yes, intervention. Thank you, Robin. Somebody needs to deal with the fact that this man needs to be assessed and managed. Okay, but
can I also comment? Can I comment on that about against the point that I made earlier, that the adjudicators need to be educated?
Yes.
Because that particular matter, Ms. Hinds, it went before to Marsha. It went before one magistrate to the next, to the third, to the fourth, and then they switch them around, and then they don't know the history of the case, and there's no file in the magistrate's court, and it's, you know, whatever's before the court, and no. The same way that the High Court treats matters, family matters, civil matters, you have one file, no matter, albeit how fat it is, who cares? You understand? So like, we get into the magistrate's court and it's kind of like willy-nilly. However that magistrate feels that day. Oh, you were cleaning the roof, you shouldn't have. No, protection order denied. What the F? But you know, I don't say nothing.
Funny. It really isn't funny.
I don't say nothing.
All right, well look.
So they need to be taught.
And yeah, no, we are gonna do that. That's the next line of action, is to try to get training for the judiciary, the judicial officers. But you ask yourself, how many magistrates in Barbados gonna sit down and listen to an advocate take them through 138? They know it. They know it. And my intention is never to come here and feel like I can teach the attorneys the law of 130A. My little contribution, I hope, is to get the lawyers to see 130A from a lens that is not a legal lens. Because when you do that, I think the legal lens works better to be able to provide the remedies that the law was seeking to give in the first place. But are our magistrates at the point where they can have this overarching multi-sectoral discussion of it? I don't know, but we will try.
Thank you, Marsha.
Thank you, Robin. Over to you.
And I will just quickly read out the last two comments that went into the chat by Nyla. I have successfully applied for a protection order where a woman was abusing her husband. The last straw was when she chased him around the house with a cup of hot water in her hand. The magistrate dealt with the matter very fairly. I think that is good for men to be encouraged to use the DV Act, much better than retaliation. And then Raquel's point of we need CPR for the magistrate's court. And I think that is something that we can all agree to. Thank you all again so very much for attending this evening's session. Thank you so much, Marsha, for taking us through that in-depth look of 130A, what we call our Bible, because it very much is. And we are excited on Thursday to welcome two Trinidadian attorneys at law who are also members of the Family Law Association of Trinidad and Tobago to take us through the welfare principle, as well as introduce us to the welfare checklist, which is something that is being implemented in Trinidadian courts currently, which quantifies what is in the best interest of the child and provides a very manageable checklist to be able to go through, which is again especially important in relationships that are characterized by domestic violence. Thank you so much. As always, if you have any questions or if you want anything included in the next sessions, please feel free to email us. The email address is operationsafespace.bb@gmail.com. Thank you so much. Have a good evening.